So I was just doing a podcast and the story of Andrew and Sarah came up, and it's quite extraordinary. So anyway, before running off to bed, there's another story which I ought to cover before this evening, or before I go to bed. And this is the one about the Reform UK councillor Audrey Dent told Sky News that asylum seekers and other migrants are trying to bring Sharia law to Glasgow, pointing vaguely to stacks of evidence online and conversations in the street. This is, of course, nonsense, and Scotland's First Minister John Swinney has called the claim ludicrous, absurd and divisive, stressing Scotland's priority of community cohesion. Two quick anchor points. Scotland and England have single sovereign legal systems. There is no lawful space in Glasgow where religious rulings can overrule Scots or UK law. The suggestion that a parallel penal code is being imported into city streets is false and abusive. It's part of the far-right fantasy, not only in this country, but in other countries as well. Swinney's response aligns with the Scottish Government's new Scots integration strategy, which puts cohesion at the centre of policy. Sharia in Muslim practice is a broad ethical religious framework that guides worship, family life and personal conduct. The specific fallible legal interpretations developed by scholars are called fiqh. None of this overrides the law of the land in the UK or in Scotland, where religious norms do surface in formal dispute resolution here. They only do so within state rules. And similar law courts exist in Judaism and in Catholicism. In England and Wales, commercial parties may agree to arbitrate disputes, even with reference to religious principles, but only if the outcome complies with UK law. That is the Arbitration Act 1996, not a religious takeover. Scotland has its own modern arbitration statute, the Arbitration Scotland Act 2010. Neither creates a parallel state. Both are subordinate to public law and equality law, and both keep the courts as the ultimate backstop. Much of the anxiety springs from Sharia councils. An independent Home Office review led by Professor Mona Siddiqui in 2018 found that councils in England and Wales mainly help women secure a religious divorce when a husband withholds consent. The review recommend two secular fixes, require a civil marriage alongside a religious nikah, and create proportionate regulation to protect women. Crucially, these bodies have no civil or criminal jurisdiction and their decisions are not enforceable as law. That was the government's own review tabled in Parliament. Scotland's legal architecture is different in detail, but the principle holds. No non-state body can create binding criminal or civil law in Glasgow, and where private arbitration exists in Scotland, it is creatures of the 2010 Act, and it cannot violate Scots law or public policy. Walk through the city centre and you will see is not evidence, it's rhetorical devices. Governments, courts and universities rely on verifiable data, not vibes. And when we look at public attitude research on British Muslims, the simple headline is this: British Muslims overwhelmingly report belonging and the desire to live within the law here. Polling that asks about Sharia often confuses ethics with criminal codes and produces noises rather than clarity. Ipsos Mori's meta-review warned specifically about misworded questions and sensational interpretations. There are three common conflations. The first is to conflate ethics with enforcement. The second is mediation with jurisdiction. And the third is criminal outliers with communal norms. A Muslim choosing to follow dietary rules or prayer times is not creating a rival state. A religious body can advise its adherents. It cannot jail anyone, fine anyone, seize a child or register a divorce in civil law. If a person commits an offence in Glasgow, Scots criminal law applies equally. There is one set of police, one set of courts. The Archbishop of Canterbury's 2008 lecture is often misquoted to suggest an endorsement of parallel criminal law. Read closely. It explored whether limited civil accommodations might better respect conscience while remaining under state law. Whatever one thinks of the thought experiment, it was not a call to import hudud punishments, and it carried no legal force. Glasgow has a long record of hosting refugees, from Kosovars to Syrians to Ukrainians. The new Scots strategy now runs on a whole-of-society model, language access, employability, housing coordination, civic participation, because cohesion is built by contact, not by culture war alarms. That approach is the exact opposite of the takeover narrative. So what to say when confronted with "they are bringing Sharia"? Offer a short, firm 4-point reply about law, councils, arbitration and cohesion. There is one criminal and civil law in Scotland, no exception. So-called Sharia councils are advisory bodies with no state power. Government reviewed them and proposed civil law fixes to protect women. Any private arbitration in the UK operates only within statutory limits and under court supervision. It cannot breach equality law or public policy. And Scotland's stated policy is to strengthen community ties and integration. Leaders inflaming suspicion put that at risk. So why does the rhetoric matter? Because language that paints migrants as a monolith importing alien rule is not harmless. It correlates with spikes in street harassment, with distrust of institutions, and with the very polarisation that weakens the city's ability to solve practical problems such as housing, health access and school places. The First Minister's point about cohesion is not cosmetic, it is the condition for everything else to work. So there are reasonable steps that can be taken in Glasgow and Scotland and England, of course. So there are measures that are pro-law, pro-women's rights, pro-cohesion. Firstly, to close the nikah-only gap, echo the Home Office's reviews, core recommendation in Scottish terms, ensure that religious marriage sits alongside civil registration, so that women have full rights in Scots law. This reduces the shadow market for unregulated councils. Publish a local fact sheet. Police Scotland, the Crown Office and the Glasgow City Council can jointly restate the single law principle in plain English and key community languages with a hotline for family law and domestic abuse support. And invest in early contact integration. Back the New Scots delivery plan at city level. ESOL within 2 weeks of arriving. Skills recognition in months, not years, and structured civic mentorships. The evidence base for cohesion through contact is strong, and Scotland is working hard to integrate migrants. And finally, the data, discipline and debate. Media and councillors should cite verifiable figures, not anecdotes or viral clips. When claims are made about crime, insist on Police Scotland data. This is a story promoted by an aberrant reform babbler. Glasgow's law sits in Parliament House, not on TikTok. Our city is governed, or the Glasgow city. I have many friends in Glasgow. I look upon it as a place of great comfort, and I remember going to Glasgow when I was first an undergraduate and enjoying the place enormously, and visiting the Citizens Theatre, and I treasure my Scottish links, and I look to Scotland to see what is being done well, and often things are being done well in Scotland. Scots law, policed by one force, judged by one set of courts. People of many faiths live in one city under the same rules. If there's evidence of crime, bring it to the police. If there are only rumours, don't bring them to the public square. It's absurd. It's absurd. And as for Reform UK, if it's not got anything of value to say, it should shut up.